So I'd like to start by acknowledging the traditional owners of the land we are on today, the Wadawurrung people, and I extend my respect to their elders past and present and any Aboriginal or Torres Strait Islander people who may be present today. My name's Bec Dahl. I'm a principal lawyer at Nichols Family Lawyers in Geelong, and we also have an office in Melbourne. We provide legal advice on a range of family law matters, including divorce, de facto relationship law, children's matters, complex property settlements, LGBTIQA+, family law, and family violence. So today I'm going to speak to you about the national implementation of the paid and domestic violence leave policy, which became accessible to all employees as of August 2023. And through my practice as a family lawyer, I've gained significant expertise in assisting families with experiencing domestic violence. And what that means is I've witnessed firsthand the profound implications it can have on families, individuals, and businesses when it's not addressed effectively. So today I'm going to talk really around the obligations entrusted to businesses in the implementation and ongoing maintenance of the paid family and domestic violence leave. I'll talk about what the leave is, what actually family violence is, intervention orders, employers' responsibilities, impacts on productivity, supporting your employees, supporting yourselves, confidentiality requirements, and then a little bit about us. And I am more than happy to take questions at the end of the session. So, starting with what the family domestic violence leave policy actually covers. So employees in all non-small businesses, which is a business with 15 employees or more, and small businesses being with less than 15 employees across Australia, are eligible for up to 10 days of family and domestic violence leave in each 12-month period. This extends to all employees, including casual employees. The overarching purpose of this policy is to provide support for people who are wanting to leave abusive relationships or are navigating the impacts of those relationships, and enables them to take time off work without the fear of losing income or employment. So the introduction of this policy and the leave by the federal government back in 2023 replaced what were people's previous entitlements to unpaid family and domestic violence leave for up to 5 days a year. So within this framework, which comes from the National Employment Standards, it means that employees are given the support they need to address situations around family and domestic violence, particularly where doing outside of their work hours is impractical or actually just unsafe. So another thing to be aware of is that unlike some other sorts of leave, employees are entitled to access this leave from their very first day of employment in your business. It doesn't accrue over time. It renews each year on the anniversary of the employee's commencement with you. It doesn't all need to be taken at once. It can be, or it can be taken multiple days as needed. And this leave is in addition to any other leave entitlements that people have: annual leave, parental leave, sick leave, etc. So full-time and part-time employees get paid their complete pay rate for the hours they would have worked if they weren't on leave. And for casual workers, the payment is based on their full pay rate for the hours they would have been rostered on during the period they're taking the leave. So if a casual employee takes this leave during a period that they weren't actually scheduled to work, they wouldn't be eligible to be paid this leave during that period. And when I talk about their full pay rate, it encompasses their base rate as well as any additional payments, bonuses, loadings, allowances, overtime, penalty rates that they would usually be paid. Now, individual workplaces do have flexibility to outline their leave with different agreements and contracts or policies, but this is the mandatory minimum that all businesses provide their employees with that 10 days of paid family and domestic violence leave. So I think that's, I suppose, the starting point of what is the leave. But I think what's useful, particularly if you are an employer who has an employee who comes to you and needs to access this leave, to understand what it is that they are experiencing. So when we talk about family violence, we're talking about behaviour that's violent, that's threatening, that's abusive, that is trying to control or coerce someone, or is trying to cause them fear. Now, to access this leave, the person who is perpetrating this violence could be a close relative. So that's people like spouses, former spouses, de facto partners, children, parents, grandparents, siblings, anyone who's a close relative. It could be a member of their household or a current or former intimate partner of that person. The other thing I think is helpful to understand when we're talking about family and domestic violence is actually what does it look like, because it's a very broad term, and I think sometimes if it's not something that you have been exposed to or know about, it can be a bit scary or confusing to understand what we might be talking about. So there's a really wide range of behaviours that are considered family and domestic violence. Now, this isn't a limited list, but some of the things we know are this behaviour are physical violence, sexual assault, verbal abuse, emotional or psychological abuse, threatening or abusing pets, financial abuse, stalking, obsessive behaviour, neglect where there's a relationship of dependence, for example, someone's reliant on someone for their care, and damage to property or belongings. So all of these things and more, frankly, fall under the definition of family and domestic violence, and are the sorts of things that the employees who come to you wanting to access family and domestic violence leave might be looking at. I wanted to also specifically mention coercive control there, because that is something that we hear a lot about, and it is a really serious form of family and domestic violence, as all these things are. But coercive control is something I think we're starting to recognise a little bit better. And coercive control, rather than an isolated incident, which is, not a good thing in and of itself, of course, but coercive control is behaviour that's a pattern of manipulating and controlling behaviours designed to intimidate, isolate, or dominate someone. So they can be things like isolating someone from their friends and family, controlling where they go, what they do, who they see, monitoring them, dictating what they wear, what they eat. And it's really behaviour that is designed to erode that person's self-worth and independence. So I just thought worth mentioning as a specific, I suppose, example. What do we know about family and domestic violence? Well, we know that the impacts are huge. There's the impacts on the individuals that are experiencing it. There's the impact on the families that are part of that person's broader world. And there's impacts on the broader community. So some of the things that people can be impacted by, and this may be relevant to staff who are looking to access the leave, sounds obvious, but physical injuries. So people might experience broken bones, cuts, burns, that need medical attention or attendance at doctors or hospitals. People might experience emotional trauma. Domestic violence really can cause anxiety, depression, post-traumatic stress disorder, other mental health issues, which can affect people's everyday lives, frankly. Financial consequences, medical bills, loss of income, which is really what this is designed to protect. But you can imagine that people, often are missing beyond 10 days of work. People may have lost property, have to relocate. People who are experiencing family and domestic violence also often become very socially isolated. That may be because that's the intention of their perpetrator, but it might also be because they are experiencing anxiety and depression and other mental health impacts from that behaviour. So something else to keep in mind there are just some of those consequences. I wanted to touch on some statistics which are very scary, but I think very important to really understand the prevalence of family and domestic violence in Australia, and really, I suppose, understand that it very, very likely may be something that is happening to someone in your workplace. So, to offer a bit of context, so stats say that 1 in 6 women and 1 in 16 men experience family and domestic violence in their lifetime, which is really significant. We know that in Australia, shockingly, 1 woman a week is murdered by her current or former partner. There were 97,800 family or domestic violence offenders recorded by the police in the latest report by the ABS, which was up 8% from the last assessment. And it's estimated that 11.8% of Australians, which is 2.2 million Australian adults, have encountered some form of family violence from a partner. The other thing we know is that family violence is more prevalent in certain demographics and in certain geographical regions. So in Australia, family violence is the biggest cause of early death, disability and illness in women between 15 and 44, which is incredibly frightening. Women in regional, rural and remote areas are more likely than women in urban areas to experience family and domestic violence. Women with disabilities are almost 40% more likely to experience family violence than other women. And as employees, I think it's really important to keep some of these things in mind to help, I suppose, identify whether there are people in your workplace who may be more vulnerable to this than others. The other area where we see a really elevated risk is from the LGBTIQA plus community, and there's some very specific sorts of family violence that come from for that community in terms of their families of origin, perhaps rejecting them, not supporting, parents not supporting them, that sort of thing. So just important to really look at that. So understanding those stats, when we look at risk factors, we know that family violence affects people from all walks of life. It doesn't discriminate by race, socioeconomic status. We know more women experience family violence, but it doesn't discriminate by gender, and it can be happening to anyone, anywhere. One of the things we know that's really emerged has that the escalated cost of living in Australia has increased the risk of family and domestic violence, because we've seen that these rising costs have increased the demand by up to 10% for family and domestic violence services. The other real impact on the cost of living is that it makes it harder for victim survivors to leave abusive relationships because they feel financially that's just not something that's available to them. Some of the other things that we know are risk factors are increases in unemployment, which can mean more time spent at home. We saw this in COVID. People were at home more and had, unfortunately, greater exposure to abuse in their home. I think that the unrealistic expectations influenced by social media also play a role, and there's statistics that say that has been recognised as a contribution to the risk of family and domestic violence. So whilst it's unfortunately something that's always been there, we know that there are these certain factors that can exacerbate the risks for people. So one of the big reasons that people may be using this family and domestic violence leave is because they need to get an intervention order, or they have one and they have court hearings perhaps to attend. I thought it was really probably helpful to understand what that experience or process might look like for someone in your workplace. So if you don't know, an intervention order is a court order that people can use to protect themselves from someone causing them harm. So it's legally enforceable, and there's two types of intervention orders. So there's personal safety intervention orders, which are to protect an individual from someone that's not a family member, so for example, a neighbour or something like that. And what I'll talk about today, which is a family violence intervention order, which is to help protect someone from a family member who is violent towards them. So the first thing to, I suppose, be across when we look at an intervention order, and as I said, this is specifically the family violence intervention orders, is what is a family member? Because, you know, it can be a really broad definition, but what the legislation around intervention orders says is that family members are people who share an intimate personal relationship, so people who are married, de facto, domestic partners living together, parents and children, relatives by birth, marriage or adoption, and people that are treated like a family member, like a carer or a guardian. And the definitions can also include former partners, former people in a family relationship, former domestic partners, those sorts of things. So the way people obtain an intervention order is they can do it themselves. They can do it, children over 14, but we don't see children a lot applying for them. It's usually their parents. Or the police can issue what's called a safety notice, which is sort of an emergency intervention order, and the police will do that generally when they're called to an incident. So the person applying for the intervention order is called either the applicant or the affected person. See those two words a bit interchangeably. And the person who the application is made against, the person who's been using violence, is called the respondent. So an application for an intervention order can actually be made through the Magistrates Court website these days. It used to be a process where you had to go down to court, but it's been available online now, which is really helpful. That being said, if it feels unsafe to do that online, so say, for example, there's a shared computer or something like that, you can go to the court and speak to the court about what's happening, and they will be able to work you through whether they can do that in person or some other way for you. The information that people have to give when they're applying for an intervention order are the respondent's name and address. So the person who the order is being made against can be identified and served. You have to set out their behaviour, what's happened, why you think it might happen again, and what the impact of that is on you. You need to put the names and birth dates of your children. Even if you don't actually apply for them to be protected by the intervention order, they're usually added as a matter of course, because there's a sort of broad understanding of family violence that even if children haven't experienced it directly, it's experienced by them in the context of being in that family home. Ooh, just go back a slide. So after the order's made, some people need to go to an appointment to sign their application. And as I say, this is often somewhere where people want to access this leave because it needs to be done during business hours. So that's really important. So the impact of an intervention order is that an order is made by the court, which has certain conditions that set out what the respondent can't do. So the minimum will be that they can't use violence against someone, but there may also be other conditions. For example, they can't be in a certain distance of them, they can't be near their workplace, they can't put them under surveillance, or that they can't contact them electronically or anything like that. So that's just a bit of an outline of the process that people might be going through if they're accessing this family violence leave. So what are the employer's responsibilities? So, as I said, this law requires employees to be eligible and to be provided with family and domestic violence leave on request, and that request can't be unreasonably denied. So employers are entitled to ask for supporting evidence that the leave was taken for that specific purpose. So that might be police documents, court documents, a stat dec, a family violence order. What I will say on that though, the employer has discretion about whether they request them or not. So some businesses may say, if you're applying for this leave, we believe you, we don't need anything, but they are allowed to ask for evidence if they want to. Employers have to keep accurate records of leave taken and leave balances, and these need to be kept confidential. As I say, part-time and full-time employees are entitled to their regular pay rates. Casuals, as I say, if they are rostered on. One of the other things I think is really important to understand is the requirements around pay slips. So the fact that someone has taken family and domestic violence leave should not be disclosed on their pay slip. This is incredibly important, particularly because in many situations, a perpetrator of violence might actually have access to that information, and it may become even more unsafe for them if their perpetrator becomes aware of the fact they've accessed this leave. So the pay slip should just be consistent with their regular work schedule, just as it would normally be, nothing extra. Obviously keep your own records, but in terms of a pay slip, nothing different. It can be recorded as annual leave or other leave if the employee requests it, but as a general rule, the pay slip really needs to be business as usual and no reference to the fact that that leave has been taken. This is really important and really serious legislation, and I think that that's evidenced by the fact that non-compliance with this by employers can result in breaches under the Fair Work Amendment Act, and there's fines from $21,000 up to $218,000. So this is something that's taken very seriously. As employees, you're bound by a duty of care. You need to give them a safe environment, and this really extends to this leave and the support of employees who are experiencing it. So some of the things outside of the leave, which might be things that employees can be offered, might be flexible work arrangements, working from different locations if they're nervous about someone knowing where they are, spending actually more time in the office if there's a reluctance to be at home. And also, once an employee requests that leave, it's also incumbent on the employer to provide them with resources. So I always suggest to employers, and there's some resources I'll mention at the end of this, but that you have effectively a fact sheet there ready to go. That is part of the process when someone takes this leave, that they're provided with a list of all the relevant or useful supports that they might need. From a business perspective, we can't pretend that this behaviour and this violence doesn't have a significant impact on individual and workplace productivity. So what we know is that on average, it takes someone about 7 attempts to leave a violent relationship, which is about 141 hours. The statistics say that family and domestic violences cost businesses about $2 billion in direct and indirect workplace expenses. And data from the ABS suggests that 44% of women who experience partner violence within the past 5 years have reported ongoing financial problems, compared to just 7.2% of women who haven't experienced that behaviour. I think we need to be conscious of the fact that the impacts of family and domestic violence can really flow over into other aspects of the community. So even in a workplace, there can be impacts on the people who are providing the support. They might not be trained in that, and hearing these experiences of abuse can be really triggering. So I think it's also really important to be cognizant that, you know, whoever in your business is responsible for managing this leave, whether it's HR or something like that, that there's also processes in place for them, whether it's EAP or something else, because them hearing the stories of their colleagues' violence could really be quite traumatic for them as well. I think that, as I say, that's where directing people to services can be really useful, because it means that then you're not, as an employer or a manager, feeling like you need to be providing services that you're just not equipped to. I think that also, you know, there's differences between how this leave looks or how this can impact smaller or bigger businesses. As I said, this extends to all employees. And obviously, if you've got 5 or 10 people in your business versus, you know, hundreds of people in your business, even a short period of leave is going to require rearranging rosters, asking other people to work, that sort of thing. So for smaller businesses particularly, I would say plan ahead, because you actually never know when this may come up in your business, and knowing in advance who could step in at last minute or having casual labour hire options around, I think can be really important, so that if and when this is happening in your workplace and someone needs to access this leave, you already have a plan in place about how you're going to cover that in your workplace. So some of the ideas and thoughts I have around how to help. So I think the most important thing to do, and it sounds obvious, but is if someone in your business discloses to you that they are a victim of family or domestic violence, don't ignore it. That's the number one. And look, it might be that you have internal support processes, and that might extend to things like helping people connect with family violence services or police. As I say, making sure you've got that list of support services so that someone can select something tailored to their needs. So as I said, you know, it might be that the person is part of the LGBTIQA plus community. They may want a specific service that's particularly tailored to them. Perhaps someone who comes from a culturally or linguistically diverse background might want a service particularly tailored to them. So I think it's just about knowing your workforce and what might help them. I think that, yeah, as I say, in most workplaces, people aren't trained in this. And I think that it's really important to know where you can find the support for your people outside and have that readily available. Just to, I suppose, go through that, some of the national organisations, and I'm happy to send around the slides, because these are the sorts of organisations I would make sure you have on your fact sheet that goes with your family and domestic violence leave policy. So 1-800-RESPECT, you might have heard of, is a 24-hour service, free to access telephone or online chat. There's also 1-800-RESPECT have a service directory, which is an online database that's really useful and has advice on counselling, crisis response, advice, all those sorts of things. Lifeline, you probably know, offers personal crisis and suicide prevention services. And Men's Referral Service is a men's family violence counselling information and referral service. So they're some of the things that people can access on a national basis. We're very lucky here in Victoria. We have a number of services too. So WIRE, which is the Women's Information and Referral Exchange, assists women and gender diverse people with really an ability to connect with all kinds of different services that they might need if they're experiencing family violence. So as an example, WIRE sends clients to us who we give a free initial consult to. They'll also refer to financial counselling or support, employment support, domestic violence specific counselling. So they're a really good sort of one-stop shop. Safe and Equal, or which used to be called the Domestic Violence Resource Centre, their main purpose is connecting people with short-term accommodation and transition housing, which can be really important if someone has to leave their home because of this. Safe Steps is a family violence response centre, again, can work with people to access crisis accommodation, but also similar to WIRE, give people access to different sorts of legal, counselling, other outreach services. Switchboard and Rainbow Door is, I alluded to before, an LGBTIQA plus specific organisation. Orange Door, you probably have heard of, provide support to people. They also are really good at providing support to someone who is worried about someone else's safety. So if you're an employee who's worried about, an employer who's worried about an employee, Orange Door can also talk to you about that. So I think that is something just to be aware of. Also, as employers, the Fair Work Ombudsman provides really good assistance about specifically the leave rather than family violence more broadly. As does WorkSafe Victoria. So they can give some really good advice around looking at family and domestic violence in the context of workplace risk rather than just a leave entitlement. So there's a lot of options there for external organisations. When we look at how people actually apply for this leave, so employees should really let their employers know as soon as possible that they need to access the leave. Often this really does come at a last minute emergency. So it usually is sort of quite short notice, I suppose. As I say, the employer has the option to request evidence to support the request for that leave. Now, if an employer has requested the evidence and an employee doesn't provide it, they are ineligible for the leave. But as I said, it's very much up to the employer whether that's something they require. Employees should also, as best they can, let the employer know how long they expect the leave to last. Sometimes, obviously, that can be difficult, but sort of the best they can, whether it's, 1 day to go to court or 2 days to have to move out of a house, something like that. So I think that, as I say, you need to have some sort of flexibility and understanding around these being very urgent situations and things might sort of not be readily available. So someone may have to leave immediately. They may not be able to get the documentation you've requested today. And I think that because of the nature of what people are going through if they're accessing this leave, it's really just something to be aware of. So the employee can take leave as soon as it's been provided. So as I say, it might be that day, might be the next week if they've got a court hearing they know about, something like that. And in the next pay cycle, whatever that is in your business, the employee will receive their pay as if they'd worked the hours. So as I said, very much business as usual, particularly on the pay slip. And then obviously once the leave's been taken, the employee returns to work. And it's really important, I think, to be aware of that ongoing impacts that we talked about before. And I think check in with people, make sure they know where that support is, where they can access information. And I think for your own workplace, I think it's really important to have a process ready before you need it. So it doesn't need to necessarily be detailed. I think at the very least, having an agreed point of contact so people know who they need to go to if they want to access this leave. Having an understanding of who else in the business, if anyone needs to know. As I say, having a process of covering work if you need to, making sure you've got that support list ready. I think what that does is really means that businesses aren't having to create a process under pressure, because I think what's happened since the introduction of this leave is that people have thought, oh, it won't happen here or we won't need it. So there's no process in place. And then it happens and everything has to be reactive. So I think, making sure you've got something in place before you need it, and hopefully you never need to use it in your workplace, is a really good idea. It's really important to keep confidentiality in mind. The fact that people have accessed the leave, their leave records, the evidence that they've provided, if that's something you've requested. It's really important that's handled confidentially, because, there could be really serious consequences and real safety consequences if that information got out. Some of the advice I know Fair Work gives is looking collaboratively with employees when they're taking this leave about how the information will be handled, because for each person, their safety requirements might be different to someone else's. Employers aren't prevented from disclosing the information if the employee consents to it, or if it's required by law, or particularly if it's necessary to protect the life, health, or safety of someone. I wanted to just mention at Nichols Family Lawyers, we offer a specialist legal support service that businesses build into their existing EAP program. And what our program does is gives employees, in the same way that most EAPs give employees paid mental health assistance, what this program does is it enables the employer to offer for their employees perhaps, one family law consultation as part of that service. So we really pride ourselves on those sessions being really targeted, really practical, in terms of applying for intervention orders, what they need to do financially, what they need to do with their kids, all that sort of thing. And we work with a lot of businesses that have integrated this, because what we found was that when people were experiencing family and domestic violence, or even just a separation without family and domestic violence, that the mental health support was really useful, but being able to offer that family law emergency advice alongside of it was really important. So I'm always happy to speak to that if anyone wants some more information. So, lost my. Happy to take questions. If people want to ask them now, they're welcome to. I can see there's a question in the chat about the support services, and yes, I'm happy to email my slides to anyone that registered today, so that you can have them readily available. As I say, they're just some really useful ones I think are good to put into that support document that you give to employees. My details are there. If anyone wanted to reach out directly, I'm happy to do that. But look, I hope today's been useful. I know as employers it can be a little bit scary managing this, but I think it's just about understanding